Civil Rights, Part 2. Obviously, one could spend an entire semester talking about civil rights. We do not have this time, unfortunately. What I want to add here are more some contemporary interpretations, debates about the meaning of equality and what the government, if anything, should do about it. Has the civil rights movement been successful in establishing equality? Yes and no. On one hand, the movement really managed to move the country toward more legal and political equality. Take the 1964 Civil Rights Act, it ended legalized segregation, or take the 1965 Voting Rights Act, which put an end to practices such as literacy tests, and finally, after decades, gave the right to vote to all minority citizens. In a similar vein, the modern-day women's rights or feminist movements succeeded in establishing legal equality for women in most areas. Note that many state and federal laws prior to the 60s and 70s allowed for the different treatment of men and women. This was usually justified on the basis of biological differences and different gender roles. So there were certain professions women could not work in. Why? Because it violated dominant thinking about appropriate gender roles. But is equality under the law sufficient? There's not one single answer. The answer you choose really depends on your thinking about equality, on your own personal political ideology. But without any doubt, there are remaining racial and gender inequalities. What we should do about them as a society, what government should do about it, is debatable. But here are a few statistics. Household wealth of white families is far larger, more than $113,000, than the household wealth of Latino or African American families. As a result of this disparity, whites were 5 times more likely to inherit than African Americans. And there are many disparities in education. Black and Latino students are more likely to be in high poverty schools with significantly less funding and often less qualified teachers. High school students living in low-income families are 6 times more likely to drop out of school than students from middle or upper-class families. More than 30% of African American children less than 18 years old live in poverty, compared to about 12% of white children. About 20% of African Americans have at least a bachelor's degree, compared to a lower number, 14% of Hispanics, and a higher number, 30% of whites. Statistically speaking, African Americans with a bachelor's degree make significantly less, 20% less, than whites with the same amount of education. Is legal equality enough? This brings me to recent controversies about affirmative action. Is legal equality enough, or should government be doing something, engaging in affirmative action to bring about more equality, more diversity? Affirmative action programs were first introduced by the Kennedy administration and then renewed under Lyndon B. Johnson. Sex was added to the list of protected groups in '67. Other protected groups added later were veterans and people with disabilities. So it is not only about race. The original purpose was to pressure institutions into compliance with the non-discrimination mandate of the Civil Rights Act of 1964. The rationale behind these programs is kind of nicely expressed by Lyndon B. Johnson in a speech he gave in 1965 at Howard University. Freedom is not enough. You do not wipe away the scars of centuries by saying, now you're free to go where you want, do as you desire. You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, now you're free to compete with all the others. In order to establish equal opportunity, Johnson would then say, government needs to engage in affirmative action to create these equal opportunities for people who have been left behind in the past, hobbled by chains in the past. What I want to talk about next is the Supreme Court's view on affirmative action. Do affirmative action programs discriminate and thus violate the Equal Protection Clause of the 14th Amendment, or are they justified under the U.S. Constitution? Many of the early affirmative action programs really came about as a specific quota, for instance, minority contractors that needed to be hired by a city. However, in 1978 already, the court struck down anything that relates to specific quotas. Specifically, the court struck down a special admission program for minorities on the grounds that it excluded a white applicant because of his race. So special admission programs or quotas are not permissible. Race-based affirmative action programs must be necessary to remedy past discrimination, so they can only exist in an area where there was past discrimination and must be narrowly tailored. Today's affirmative action programs are based on the idea of diversity and the assumption that diversity provides educational benefits for all, that we all learn better in a diverse educational environment, which is similar to the diverse environment we face once we enter society and the workforce. Let me talk about recent decisions. This slide summarizes the University of Michigan's admission criteria, which was scrutinized by the court in 2003 in a decision called Gratz v. Bollinger. So consider the following point system, please. 150 points in total given to a student's application. 120 of those 150 points are given depending on a student's academic standing, test scores, GPA, these kind of things. But then points are subtracted or added depending on the rigor of the high school, and again points are added or subtracted depending on the rigor of the curriculum. Extra points for certain geographical areas, extra points for an applicant having alumni status, extra points for a great essay, only 1 point, might surprise you, extra points for personal achievement, and leadership and service. Now we are getting to the more controversial part. 20 points added for an applicant's socioeconomic disadvantage, which typically means relatively poor parents without a college education, and even more controversial, 20 points for an applicant from an underrepresented racial ethnic minority. But an applicant cannot receive points in both areas. Extra points for men in nursing. The university wants to attract men applying to nursing programs, more male nurses, and extra points for scholarship athlete. Lastly, 20 extra points left to the provost's discretion. Is this fair? What the court scrutinized were those 20 points given, 20 extra points, I should say, given to applicants from underrepresented racial and ethnic minority groups. Is this fair? Because it might make up for the fact that many underrepresented students might come from less wealthy school districts where they are not given the chance to have a rigorous curriculum, no AP courses, no honors courses, not many extracurricular activities. Does it make up for the fact that many poorer students do not perform well in SATs, standardized tests? In fact, the best predictor of how well someone will be doing on a standardized test is his or her parents' socioeconomic status. Or is it a violation of the 14th Amendment and reverse discrimination against whites? Let's see how the court decided. A 6-3 majority ruled that the point system violated the equal protection provisions of the Constitution. Rehnquist argued the use of race was not narrowly tailored enough to achieve the university's diversity goals. Opponents of affirmative action were ecstatic, thinking now this would put an end to any and all affirmative action programs. Not yet. Just a couple of months later, Greta v. Bollinger, law school admission case, the Supreme Court scrutinized the University of Michigan's law school admissions. First, you need to know that law school admissions are a much more individualized process. Each application is evaluated individually. The court ruled that race can be used as a plus factor as long as there is sufficient care taken to evaluate individually each applicant's ability to contribute to a diverse student body. It was a narrow majority, 5-4. The swing vote, Sandra Day O'Connor, argued that she does not like the idea of affirmative action, but she thinks it is still necessary in today's 2004 society. However, these affirmative action-based programs should not be a permanent feature of American life, urging universities to start preparing for the day 25 years from now when it will no longer be necessary. So the idea that everyone can go to law school, then will be wealthier, probably will send their kids to a wealthier, better equipped school, and sooner or later, according to her, affirmative action programs will not be necessary anymore. Two more recent decisions. The Fisher v. University of Texas case really did not change the constitutional status quo. It reaffirmed the Michigan Law School the Michigan Law School case about individualized admissions and no blanket judgments about a person's race. The last case that is challenging the constitutional status of affirmative action is another Michigan case, Schuette v. Coalition to Defend Affirmative Action. This case has already been heard by the Supreme Court, but oral arguments will continue into 2014, and we will hear about it later in the year. Again, that's a Michigan case. After these 2003 and 4 Michigan decisions, Michigan voters passed an initiative, a ballot initiative, a referenda, remember direct democracy elements, that prohibited all affirmative action programs in the state. 58% of Michigan voters endorsed this initiative in 2006. The Coalition to Defend Affirmative Action is suing to block the initiative, arguing that just prohibiting race-conscious affirmative action programs, but no other programs that might benefit other students, is also a violation of the Constitution. So, for instance, this coalition would ask, how come the state is banning affirmative action programs, but not specific admission programs for legacy alumni admissions? To be decided. But let me sum up. Affirmative action programs are still alive, but seriously restricted by the courts. Specific quotas are not permissible at all. And who has benefited the most from affirmative action? While people of color have been helped by affirmative action, data and studies actually suggest that women, white women in particular, have benefited disproportionately from these programs.